choice of jurisdiction at the interstate level, choice of law at the interstate level, and enforcement of sister state judgments. The third dimension, which is either called internal conflict or legal pluralism, is not for every country. It is for countries that allow two or more systems of law to operate on a subject area, especially a subject area of civil law or status law. The first thing you must understand is that I told the jurisprudence class, because this topic, we also have it in jurisprudence, although we have to emphasize different issues, okay? I told the jurisprudence class that a lot of lawyers make a mistake of assuming that plurality of sources is the same thing as legal pluralism. You could have plurality of sources without having legal pluralism. And I would normally give example of their legal system in the United Kingdom. Some of their law is made of uh, their customary law, merging to what they call their common law. Okay, some are their statutory law. Some, when they became member of the European Union, will become European law. Okay, but the bottom line is that each one of these sources will operate on a territorial basis. In other words, that once you are connected with the United Kingdom, they will apply to you uniformly. So what they have is a plurality of legal sources, not legal pluralism. There will be no subject where the law will apply, the system of law that will apply to one person will be different from the one that will apply to the other. Okay? You will not have some quote unquote foreign law within internal law. You will not have that. Their legal system also recognizes religious rights, and it recognizes their residents' adherence to their foreign national law. But you won't say because of that, that a Muslim will be able, for example, to enter into polygamous marriage in England. It is the same marriage laws that apply to non-Muslims in England that will apply to Muslims. So you will not have pluralism in their family law. You will not have, once you are treated as somebody domiciled in England, that is, you are connected with England for purpose of the law governing you in the area of personal status. It is the same law that the English legal system will apply to a non-Muslim that will apply to you. It is the same law that English legal system will apply to a colored person that will apply to you. So they don't have legal pluralism. So legal pluralism is not necessarily because there are multiple sources of law. It is because And that has to be only in some subject areas. You cannot, there is no legal system that will have legal pluralism throughout the gamut of its law. You can only have legal pluralism in some subject areas. Most typically, legal pluralism would operate wherever it exists in the subject area of personal status. What are the subjects in that area? Subjects in that area are marriage, succession, wills, legitimacy, legitimation, matrimonial causes, including such issues as regards guardianship and custody and what have you. These are the areas where you largely have pluralism operating, wherever it does exist. In Nigeria, you find it extending sometimes to land transaction. That is the reason why in your land law, after they have taught you customary land tenure, they will teach you the received English tenure. And even when the Land Use Act was enacted, it sort of recognizes that both tenures coexist. And you would have pieces of legislation regulating some matters, excluding transactions that were done under customary law. For example, when you are talking about limitation, the statute regulating limitation will specifically exclude uh, land transactions done under customary law. That is to tell you that even the legislature recognizes that it is only trying to regulate limitation as it affects a particular type of uh, tenure and all of that. So that is how legal pluralism operates. And why do we have legal pluralism? Legal pluralism is a common feature of territories where the society acknowledges the heterogeneous nature of people, either from the perspective of cultural background or cultural or ethnic background, or from the perspective of the color of their skin. So you can have a regime like that of apartheid South Africa, where some laws would apply to some people of certain colors, but it will not apply to others. Then religion, you can have the society recognizing and accepting the power of religion to affect legality. You can then have members of certain religion being governed or governable by the law of that religion, with the result that those who are not members of that religion will be outside of it. That's legal pluralism. So legal pluralism is basically when you have more than one code or system of law operating on the same subject matter in the same territory. So, as a dimension of conflict of laws, the major peculiarity of this one is that we usually say that anything that is conflict in the true sense of the word must not only be uh, must be horizontal in nature and not vertical. Okay? But this particular one, is not even horizontal because the two people who are involved in the dispute affected by legal pluralism are from the same territory. The reason for the difference is not because they belong to different legal district or territory. It is because that legal district recognizes that the two or more people involved in the dispute could rightly be amenable to different systems of law. So there is nothing horizontal about their own conflict. It is just the fact that in the same legal district, it is allowed for two people to be amenable to two different systems of law. So, uh, the next thing we go to is what are the issues we have in our legal pluralism? Wherever legal pluralism operates, what are the issues we have? In the jurisprudence class, I told them that lawyers must recognize that there are no legal pluralism in a larger percentage of our subject area of law. There is nothing like a legal pluralism, for example, in the whole gamut of public law. Okay? We ought not to have legal pluralism in criminal law. After the colonial master had abolished unwritten customary law, it is only offenses that are prescribed by statute that will remain as criminal law, will remain as crime. And that's why when the colonial master found that the northerners were too attached to Islamic law and that it may have some problem if it just proscribes some crime known to Islamic law. What the colonial master did was to provide for some offenses in the penal code whose root is Islam, like criminalization of drinking of alcohol or criminalization of adultery. All these have Islamic background, but what the legislature simply did was to put it in black and white and prescribe the colonial master's own idea of a fitting punishment instead of allowing the Islamic law punishment to operate. Okay? That is what the advent of Sharia sort of abolished by prescribing those conducts not only as offenses but permitting the forgive me if I use the word crude, okay, or archaic Islamic punishment like cutting of hands, like uh, already penal code also recognizes hardy lashing anyway, but because the colonial masters thought that cutting of hand and some of the other type of punishment may be a bit uncivilized, they left them off. But the Sharia penal code reintroduced them and all of that and all of that. So that's that for criminal law. You can't talk about pluralism in the area of administrative law, in the area of in the entire gamut of public law, including constitutional law and what have you. In the area of commercial law, most of our commercial law do not have or do not have Islamic law component. I'm not too sure. I may not be sure. I may not be sure. Our brothers who studied in the northern universities, I don't know whether I'm correct on that, but I know that if a statute does exist on the subject matter, eh, that is a litmus test of how do you know whether legal pluralism operates on the subject or not. If the subject is regulated by statute and the statute does not exempt uh, transactions done under customary law, then you have no basis for bringing in pluralism. It's very simple. In 200 level, when they were teaching us legal system, they will give us the case of Okoli and Igbo. I remember that case now. A case that arose in, I think, in Plateau State, where the issue was whether a hire purchase relationship was governed by customary law or not. And at the end of the day, the court resolved the matter by saying that, well, hire purchase is not a transaction known to customary law. I'm not sure that a form of hire purchase is unknown to customary law. But I think what the judge, if I were the judge, what I would have said is that, well, if you go to the Hire Purchase Act of 1965, the Hire Purchase Act of 1965 governs, one, all hire purchases of motor vehicles, and two, hire purchase of other goods of a given value. So, if the Hire Purchase Act governs hire purchase of motor vehicle, and there is nothing in the Hire Purchase Act to exempt any hire purchase transaction because it is done under another law or another system of law. It is absurd for a hirer or a owner to say my own was done outside of Hire Purchase Act. The Hire Purchase Act is a territorial piece of legislation. It is supposed to govern every hire purchase of motor vehicle done everywhere in Nigeria. And so it doesn't leave any room for you to argue that you did your own under customary law. That is how you know whether there is pluralism in a subject area or not. If you begin to use that type of test, you will see that pluralism exists in land tenure because all statutes regulating land transaction recognize that. Pluralism exists in marriage and matrimonial courses because right in the Marriage Act itself, you will see that there is a declaration that the provision does not govern customary law marriages. If you go to the administration of estate laws of every state, you will see that they have told you that their own statute would only regulate inheritance of persons who died while married under the Act. So if you have a polygamous marriage The the administration of estate laws do not govern the distribution of your estate. So you don't even call it into application when you are talking about how to distribute the estate of a polygamous person. Okay? So it's not easy. It's not difficult to identify subject areas where we could have more than one law or more than one legal system operating on a subject. It's only that we are not methodical and all of that. So then the next thing is, what are the issues? What are the issues that uh, legal pluralism, what are the issues that they throw up? Okay? The first thing you must understand is that in any subject area where you have legal pluralism, then you would have what is called personal system of law. So you and I are both Nigerians or Lagosians, but the law permits us to discriminate between ourselves on the basis of maybe our tribe. So I am a Yoruba person and I am amenable to the custom of the Yoruba people, which you may not be amenable to. That's if you choose to be amenable to customary law anyway. I am a Muslim. One of the options open to me is to be amenable to Islamic law, which you, who is not a Muslim, will not be amenable to. Okay? So the very first question is amenability. What is the amenability test? How do we determine who will come within the purview of people governed by one system of law and not the other? We call that connecting factor. What are the factors that connect you with a personal system of law? If a legal pluralism operates on the basis of race, the connecting factor will be self-evident, the color of your skin. If a legal system operates on the basis, if a legal pluralism operates on the basis of ethnicity, then you want to use the ethnic group into which you are born. Okay, birth into an ethnic group becomes a connecting factor. If it is a religious, if it is on religious ground that legal pluralism operates, then you want to use adherence or birth into a religious group as the basis of being connected. So that's the first issue. Under this heading, you sometimes have a problem. We have said the basis of operation of personal systems of law, legal pluralism, is either race, which we do not have in Nigeria anyway, or ethnicity or religion. Okay? But some of the time, the two bases will operate in one particular case. Compare, for example, the situation of the northern Muslims and that of the southwestern Muslim. The fact that you were born a Muslim does not answer the question whether Islamic law would apply to you on the matter, because you would also have been born a native. You would also have been born what? A native. Sorry, let me pick some of these calls. I'm getting too many calls for my liking. So, as I'm saying, one of the most problematic issue that southwestern Nigerian courts have faced is cases where the court will have to decide whether a propositus was amenable to customary law or to Islamic law because he is a Yoruba Muslim or he was a Yoruba Muslim. And cases like this will often come up in inheritance matter. They will often come up in inheritance matter. You want to share the estate of a deceased. You will suddenly find people who say Islamic law should cover. And what is their reason? The deceased died a Muslim, and Islamic law has a code regarding the distribution of estate of intestate estate of dead Muslims, which you will find prescribed in the Quran and explained in the Hadith and all of that. On the other hand, you have people who say, what Islam are you talking about? This man was a native chief and he should be governed by customary law. The man is long gone. It is those who want to benefit from his estate that are picking and choosing what pays them. Okay? And then the court. How does the court decide the matter? If the court understands this topic very well, that the problem that they have is a question of amenability, and why the problem is compounded is that the disease was potentially amenable to both Islamic law and its ethnic customary law. They would have gotten the answer properly. But you will find them at the end of the day applying a territorial test, which is the exact thing that we said that legal pluralism does not throw up. You find the court saying, no, 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 he's a Muslim from Ijebu area. If he was a Muslim from northern Nigeria, the Islamic law will apply to them. And in my write-up in this area, I say that is applying a double standard because we knocked out territory from the nature of the issue. We accepted that the propositors could be amenable to Islamic law or customary law. To start using territorial distinction again is to use double standard. And in my write-up, I would then say that what the court should do is that if a person is potentially amenable to two bases of differentiation, the court should study the whole of his life to discover which one he actually elected. Okay? If that rule is applied, most of the cases that our courts grapple with, they will not need to grapple with them. Okay? You were born a Muslim, you were born a native. That gave you the option of picking and choosing. But the way you live your life will show which one you did. For example, you are a man and Islamic law permits polygamy. But Islamic law's polygamy is a limited one because you are not permitted to take a fifth wife. If you want to take a fifth wife, you will have to divorce one of the four you had before. Okay? So if the story is told that a man, I remember having a discussion like this with my dean, maybe somebody sought his legal advice and he wanted me to contribute. But the moment he told me that the man was a Muslim and he had a fifth wife, I said the man did not elect Islamic law to govern his marital life. He opted out of Islamic law the moment he took a fifth wife without divorcing any of the first four. Okay? If Islamic law were to operate on a territorial basis, you will be right to say the fifth marriage was a nullity. But Islamic law operates as a personal system of law. And the man who was amenable to it was also amenable to customary law, which does not limit the number of wives he married. So the only basis upon which you would allow the law to validate his fifth marriage is to say that he chose customary law. You will not say, but this is a Lagos area. Islamic law does not operate in Lagos area. Who told you so? You need a declaration before Islamic law will apply to Muslims. If a man lived his life as a Muslim and it's clear that that was the option he wanted, you will be very wrong to say that because he's also Yoruba and because he is from the south, Islamic law does not operate to him. So you will find the cases, you will find the court assuming without establishing that an Omohara man must be amenable to Islam, whereas an Okuku man will not be. What is their reason? Geography. Omohara is territorially in the north. Omohara, incidentally, is the place where Pastor, what's the name of this fairy pastor? The one that is at
Oyedepo.
That's where it comes from. So you say because it is Omohara, Islamic law will apply. But because the man comes from say Iragbiji, Islamic law will not apply. That is a wrong test. It's a wrong test. The proper test is for you to assume that if he was born a Muslim, whether he was born in Omara or Okuku, he was equally amenable to Islamic law or customary law. And then you look at the way he lived his life to say, no, this one ran his life in the Islamic way, and therefore distributing his estate should be according to Islamic law. That is the test you want to apply. It's not to begin to look at map of Nigeria and draw it in your mind and say, no, this right will be not this right. You don't understand what you are doing. Okay? So that's the first question. How do we determine connecting factor? What factor connects a person to a particular personal system of law? The second issue is change. Is it possible when once you are connected with one personal system of law for the facts to throw up the point that you have left that personal system of law and change to another? We've seen cases where people who married under customary law or Islamic law, or who married under Islamic law, for example, in England, and as non-English domiciliary, English conflict of laws will recognize that their marriage was potentially polygamous. But the moment they leave that religion, which connects them to polygamy, English court will recognize that their marriage has mutated because the facts has indicated that they have changed. That's what we mean, whether when the factors connect you with a personal system of law, the courts should recognize that those factors are no more, and therefore you are no longer amenable to that law for the purpose of your status transaction. So that's the second issue. And that issue, in the context of the Nigerian law, is wider because you could be talking about opting out of customary law for the general law. You could also be talking about opting out of one system of customary law to another one. We have cases. We have Olowo and Olowu. We have Adesiboka and Yunusa. All in which the court tackled that issue of whether it is possible for a person who, by connecting factors, is amenable to one ethnic system of law, can now be recognized as having opted out of that ethnic system. Olowo and Olowu, you remember, was the case of an Ijesha man who settled in Benin. Okay, in Adesiboka and Yunusa, an Omohana man had settled in Lagos. In both cases, the court were invited to recognize that the ethnic customary law yeah. Sorry, gentlemen. Let me just see somebody downstairs and come back. Sorry, gentlemen. So, as I was saying, in those two cases, the issue of possible opting out of one system of ethnic customary law to another, or of opting out of Islamic law to the general law, arose. You can say, well, they are factually different, but it's the same principle. It's the same principle. The the court in Adezibuka and Yunusa was talking of how a person can become amenable to the, because the court in Adezibuka and Yunusa more or less treated Islamic law as customary law. And so the argument in Adezuka Yunusa was that Islamic law could not apply because though Adezuka Yunusa was from Umara, where the court presumed Islamic law would apply, he had settled in Lagos, where the court presumed Islamic law could not apply. So the argument was that all argument about Islamic law is irrelevant because even though this man had died a Muslim, he had settled in Lagos. So Bello J, as he then was, had just treated the matter as a question of, had just treated Islamic law as customary law. Okay? Islamic law as customary law of the Northerners, and Yoruba ethnic customary law as the customary law of the Lagosian. And he then said that the fact that the man lived in Lagos cannot operate to make him assume that he has become amenable or he has ceased to be amenable to Islamic law, which operates according to him in the geographically north of Nigeria. He then gave a formula. He said that before somebody would be deemed to have become amenable to the customary law of another area, he would have lived in that area for so long that he would be deemed to have matched with them, something like that, a test like that. And so for him, since the man was born in Omara, all the evidence were not sufficient for him to think that Islamic law would cease to be applicable to him. Okay? But in Olowu and Olowu, a case which is celebrated because it's about the first time that a Nigerian court will accept that you could become amenable with the custom of the people you are living with. The court eventually accepted that an Ijesha man who had lived all his life in Benin and married Benin women, gave his children Benin names, would, with regard to his intestacy, be amenable to Benin customary law. Okay? Professor Agbede analyzed that judgment painstakingly and said that he had no problem with the court's conclusion on the matter, but he had a problem with what they seem to be suggesting. He said his own problem was with their emphasizing the fact of the Oba of Benin conferring Benin nationality to the man. He said that that's not a fact that will repeat itself, because the only reason why he had to do that was Benin people have a custom that you can't hold land unless you belong to them, but that under a Republican Nigeria, any Nigerian is free to hold land anywhere. And so nobody would need to beg the Oba before he could hold land anywhere again. And Abede then said that if only they had applied a test that is equal to domicile, that domicile, it is recognized that it can change. And the facts that will make you change your domicile is also enough to make you change your personal system of law. Okay? Instead of applying a test that look like nationality by saying that his application to the Oba was the crucial factor. So, bottom line is that Olowo and Olowo recognize possibility of change, and it recognized it in that circumstance. But there are other issues of change that our courts don't usually recognize. Okay? You are amenable to customary law, so you are a candidate qualified for polygamy. But the marriage ordinance says that once you take a first wife under the Marriage Act, you become disqualified to take a second under customary law. So the offense of bigamy, you become qualified to be charged for it. You become qualified with regard to your intestacy to be governed by administration of estate law. All of these you should know by the time you decide to take a woman to the registry. But what do you find today? You will find people who have done registry marriage with others, and then tomorrow they change their mind, they want to have a second wife. And you find the courts discussing the issue as if it's a question of religious rights or a question of right inherent under customary law. I think the courts don't understand the topic. You opt out. The fact that you were amenable to a particular, the code of a particular legal system, whether customary or Islamic, does not mean that you cannot opt out of it. And one of the easiest way to opt out of it is that if you have an alternative that has its own surrounding rules, you cannot opt into that alternative, and the court will still assume that you are not governed by its surrounding rules. So you will find cases where the court will try to say that yes, he has married under the act, but that did not take away his right to marry under customary law. When the statute itself prescribes so, okay, our courts will need to look at those issues fairly well again and understand that once you say there's a pluralism, the meaning is that citizens have options. They can opt in and opt out. The one that is most difficult to accept is when the opting in and opting out is based on ethnicity. But if the court has accepted that even an Ijesha man can become amenable to Benin custom, why is it difficult to accept that a person otherwise amenable to customary law, which gave him a right of polygamy, opts out of it the moment he chose an act marriage with its attached consequences? Okay? So that is the second question, whether you can change. And the third one is the one that is our whole problem in conflict of laws, which is we are in the same state. I'm amenable to A, ethnic customary law. You are amenable to B, ethnic customary law. But we are entering into a status relationship. If tomorrow there is an issue, the court will have to determine, the court will not formulate a third law. The court will have to determine which of the two laws will govern our issue. That's the That is the one that you sometimes find our high court laws trying to regulate by saying that if the conflict is between English and customary law, uh, uh, and the person we are talking about the people we are talking about are basically natives, customary law will apply. But if the question is between two systems of customary law, they will also attempt to regulate it one way or the other. So those are the three questions. But so those are the three questions that legal pluralism will throw up. There are so many other issues in that subject area that I do not want to bore us with. I have some writings in the area. I will look for them, send them to you for you to understand what we are talking about. But after this class, even if you find it written in a textbook, as you find in many legal system textbooks, that Nigeria is a legal pluralism because Islamic law operates, customary law operates, that's not the reason why Nigeria is a legal pluralism. That only shows that we have plurality of sources. Okay? The reason why Nigeria is a legal pluralism and the reason why the pluralism does not permit all the subject areas of law is because it is only in some subject areas of law that our legal system permits two or more systems of law to operate. And in those subject areas where two or more systems of law operate, all of the three questions I've thrown up would usually arise. And what we are supposed to do is to develop a jurisprudence around those three questions with sound knowledge, not with idea. The first question is, what factor connects you with a personal system of law? Which becomes very irrelevant, especially in places where a person could be amenable to two of the connecting factors at the same time. The second is, how does the court recognize change? How does the court recognize that you have opted out of one and gone to another? Whether you are opting out of an ethnic system into a general system or one ethnic system into another, how does the law recognize it? And the third one is, when relationships are formed across personal system line, the law that must govern the dispute that will arise must be one of the two personal systems. How does the court determine which of the two personal systems will govern? Those are the three questions. And there's a need to do a jurisprudence around those three questions. Okay? You may not find guide in our court pronouncement because the courts hardly exhibit understanding of the subject area themselves. But we need a guide around those three questions. Okay? Maybe one day I will stop being lazy and I will do a basic test. Okay? Answering those three questions in the Nigerian context. So let's leave it like that and let move to the next paper. Or is there anybody who has a question for me?
Yes,
Good
sir.
evening.
Hello?
Yes, I have a comment, sir.
Yes.
Okay, so I was thinking that could it be that because our courts are always overwhelmed with a lot of cases, that's why
It's not because they are overwhelmed with a lot of, they don't understand the subject
that's
area.
why I'm
Just as
going.
simple as that.
Yes, I'm
They,
listing two reasons. I'm also going to make that point. And the second one is I'm just looking at what are your recommendations? You have identified the issues, sir. So is there a way that our judges are being trained on this subject area, like this conflict of law, for them to apply the tests you have stated in this class?
Well, I don't know whether it is the court I will blame or whether it is people like me. Do you understand? We can popularize these topics, do write up on them, and let people understand what we are saying. I'm very, very sure that when there are enough literature to read on it, the court will begin to understand the issues. A judge will not tell me that because somebody is from Omuara, because not only is he a Muslim, he was born in Omuara, Islamic law applied to him. But even if he's a mullah, a sheikh, the fact that he was born in Lagos will mean that Islamic law does not apply to him. In one of the cases, we find the court say, Ijebu is not an Islamic area. What does Ijebu need to have to become an Islamic area? To be conquered by Danfodio? Is that what will make it an Islamic area? I think the court they are just messing the issue up. If a man is an Ijebu and a Muslim, the fact that either Ijebu customary law, Islamic law could apply to him is not the reason why you will rule out the application of Islamic law. You ask yourself further question. If it is the intestacy of the man that is an issue, then his whole life will be examined by you to see the way he lived it. You will take evidence, okay? Evidence of the religious right that he performed is not enough. For example, the fact that he was an allergy does not mean that he will not marry a fifth wife. Eh? You
Yes, sir.
understand what I'm saying? You
Yes.
won't use that one as an overriding factor. But it's a factor too to show that this man lived his life as a Muslim. But if you have other evidence that this was a man who at one point in time harbored 8 women in his house as his wives, you can say, no, but this one, he already opted out of Islamic law for the purpose of his marriage. Because if he was a Muslim truly, and he chose Islamic law for purpose of his marital life, he won't have a fifth wife. He won't have a fifth wife without divorcing one. So the only system of law which can save his marriage is to say that, well, the man was equally amenable to Islamic and customary law. But we can see that he never adhered to Islamic law when the chips were down. So the only system of law that is left to be deemed amenable to is ethnic customary law. And that will be logical. It will be more logical than you to say, oh, look, this man was a Muslim, but he was born in Ikerun. If he was born in Ofa, I would have said Islamic law applied to him. What rubbish. The area we are talking about does not emphasize territory. It emphasizes personal system. The test is a personal one, not a territorial one.
Okay, sir.
So all of us will have to educate ourselves in this subject area. We will have to understand the logic of pluralism. We have to start from the very definition. Okay? Legal pluralism is not plurality of laws. There are many countries with plurality of laws, but each of the law operate on a territorial basis. It is when laws operate on a personal basis that you have legal pluralism. If you have one law and the source of that law is different from the sources of other laws, the fact that that law operates on a territorial basis, that is, it governs everyone, it does not discriminate between people, will not make that legal system a legal pluralism. Okay? If we want to take another paper, we should let the presenters talk now.
Hello, sir.
Yes.
Yes, sir. I have a question, sir.
I also have a question.
Okay, maybe we should just discuss only this one for today and take the next two papers next time. So, what is your question?
Yes, sir. Given the fact that bigamy is a crime, then a man who married under the act and now subsequently take another wife in violation of the act, which is meaning he has committed a crime, can that also be allowed to justify this principle of amenability that he has opted out of monogamous
I
marriage?
gave an example. I said that, look, you are a native or a Muslim. You can never commit bigamy if you don't opt out of it. But the moment you opt out of that your cover, that your protection that permits you to sample women and decide to go to the registry with one woman, the day you are going to the registry, you are declaring that I become a candidate for bigamy. I become a candidate whose intestacy will be governed by administration of state law. I become a candidate who would have children, whose children out of this wedlock, I would have brought them into the world with the status of illegitimacy. You yourself, you are the one making the declaration. Okay? You are the one making it. It's not nobody is forcing you. So if you know that you want to remain in those pleasurable rights that your ethnic customary law, Islamic law confers on you, don't take a woman to the registry. But you take a woman to the registry with your eyes wide open, and then you begin to argue that your religious law confers on you a right to take a second marriage. Nobody took that right away from you. You of your own took it away from yourself. So I don't know whether I satisfy you on that.
I think so. Okay, good evening, Prof. I have a question to ask.
Yes.
Okay, I want to ask a question based on Olowu versus Olowu 1985 case you cited, Prof.
Yes.
Okay, yeah, I just want a proper clarification. If, for example, an Igbo man got married to a Yoruba woman, and along the line, the Igbo man know how to speak Yoruba very well, and also probably being confirmed a chieftaincy title in Yoruba land. So if going by that Olowu versus Olowu, if, for example, the man died, would Olowu versus Olowu be used? Can it be used to on the testacy of the man?
That's exactly what Agbede was criticizing. Agbede said that in the context of Olowu and Olowu, the Supreme Court were laying down a fundamental principle that what you are saying is possible. But instead of them emphasizing what they ought to emphasize, you find all the 7 justices giving different reasons. Some of them said what was important, okay, was the fact that the man had to get the Oba of Benin to naturalize him. Today, in that example you are giving, will you really need the Oba of a Yoruba town to to naturalize you before you become amenable to their custom. So if we use that as a test, somebody will say, but Olakindolowu, this one, nobody conferred Yoruba nationality on him. And Professor Agbede then said that particular fact ought not to on itself be the deciding point. It ought to be taken together with other facts. The fact that the man will become so accustomed, so used to the new ways of doing things, marry their women, give his children the name, Benin name, speak Benin language in his family house, and all of that. They will all combine together to constitute the fact of opting out of the Desha customary law and opting into Benin customary law. But the moment you emphasize the fact that the Oba of Benin had to give it, then you make the case lose its radical character of establishing a rule that can be followed in the future. Okay, Professor Agbede in particular said that request for him to be given Benin citizenship because before he could acquire land will no longer be applicable because every Nigerian now, by virtue of the constitution, can hold land anywhere in Nigeria. And so nobody would apply to Oba of Lagos to acquire land again. And so Olowu and Olowu to be used as a precedent will then become difficult because the facts will not be at all false. That's the criticism of Professor Agbede. But that if the court had understood and declared as they had the right to declare that, look, when you are originally amenable to a particular ethnic customary law, you could opt out of it. Okay? Not only by relocating to a place where another ethnic customary law is what operates, but by merging with that community, adopting their way of life, so demonstrably that if somebody is not told that you are from Ijesha, nobody will know. That was Agbede's criticism. Read Agbede's article again. You see, that was his criticism against the reason for the Supreme Court judgment. Okay?
Yes, sir.
We seem to prefer the test that Bello J had formulated in Adesubuka and Yunusa. Where Bello J was saying that, yes, you can match with a community by living with them for so long that you have become, I think he used the word acculturized or something with the people. Okay? Unfortunately, Bello J did not eventually apply his test in determining that the late Yunusa was amenable to Islamic law. He thought that his test was not met. Okay? I have two problems with his decision. The first one is applying a geographical test to say Islamic law could not apply to the late Yunusa or is it Adebutuboka. The second one is formulating a very beautiful test and refusing to apply it. Okay? So to answer your question, we are going to rely on precedent. It may be very difficult because Olowo and Olowo, the case we are relying upon, would easily be distinguished Because the other party will be able to tell you that, but in Oluwandolo, the man applied for naturalization as a Benin person. Even though we know that the reason why he had to do that is when he wanted to buy land, Benin people do not sell land to non-natives. So he had to naturalize to be able to acquire land. The fact you are giving now, we definitely not include that. And for that reason, Olowu and Olowu will not serve the purpose. We would have been happy that it is serving, because that particular fact of naturalization will not repeat itself.
Thank you, Prof.
Yes.
Prof, I have a question to ask. And
Yes.
my question is this: based on what you have taught us today, will it be correct to say that for a northern Muslim, where their personal law is Islamic law, will it be correct to say that there is no legal pluralism applicable to a northern Muslim? Because when it comes to succession,
There is a legal pluralism. There is a legal pluralism. They can opt out of the so-called Islamic law too now. Do
but
you
sir, they are
understand? They
okay,
also,
sir.
for example, if you are talking about marriage, they also have the marriage ordinance. In fact, the Marriage Act is a federal legislation that applies to them. So I can opt out of Islamic law by taking my wife to the marriage registry. That particular conduct has its consequences, which include taking away from me my right to take a second wife. So they also have a legal pluralism. A Muslim can marry a non-Muslim. Okay? You have the twin issue of capacity and formality. If a Muslim marries a non-Muslim in the church, followed by a registry thing, do you think that because the person is a Muslim, that marriage and its incident should be governed by Islamic law? What you will find in the northern cases is because we are very used to majority oppressing minority. You find the courts and the lawyers all stay on one side of the argument that because it's a Muslim, the other person who is a non-Muslim does not have a right to insist on the contractual implication of the type of marriage they did. That cannot be right. That cannot be right. Yes, he's a Muslim, and we know that his Islam confers on him some rights. But he, with his eyes wide open, has opted out of it. Do you understand what I'm saying?
Yes, Prof, I understand.
And so pluralism will still operate. If you don't want pluralism to apply in the subject areas otherwise governed by pluralism, stick to one personal system of law. You want to do your marriage, if you want to marry a non-Muslim, let her agree to convert to Islam. Do the marriage only in Islamic way. Do not anything crop, no, do not allow anything to crop in that will bring about conflict of laws. Because if you allow that to happen, then the court, in fairness, is supposed to look at the two questions: the question of capacity and the question of formality. You cannot marry a non-Muslim under the Act and say, hey, you, because you are a Muslim, you are entitled to take a second, a third, and a fourth wife. Didn't you know that that is the position? When she, who is a non-Muslim, and possibly does not have the right under our personal system to be in a marriage where the man takes a second wife. Of all the people you could see, it is her you wanted to marry. And if she would ask you at that point, you say, no, I won't take a second. Then after you have done that, you suddenly remember that you are a Muslim. You already opted out of that Islamic law. You opted out of it. Your marriage is governed by a marriage act that forbids you from taking a second wife. There's nothing constitutional about it. People will then begin to refer to Section 38. It is Section 38 that talks about right of religion. And I will have a dick. What has right to religion got to do with it? Nobody is forcing you to live your religion. You opted out of it. How can you be eating your cake and having it at the same time? So that is the issue.
Thank you, Prof.
Any other question?
Yes, sir, Prof.
You
I have a
may find that
question,
my
sir.
opinion is not a very popular opinion, no? But I'm giving it on the basis of my own understanding of the meaning of legal pluralism. Okay?
Yes, sir. Um, Prof, sir, I have a question, sir, and in the course of my research, I
Mm.
I look at the principles that is guiding legal pluralism, and I discovered that there are about 6 principles. And the first one
Mm.
was the principle of personal law, and the second one was the principle of voluntary submission. Then the third one was the principle of territoriality, and the fourth one was the principle of recognition of customary law, and the fifth one was the principle of justice, equity, and good conscience. And the sixth one was the principle of party autonomy. Now, my concern is this. As I was listening to your wonderful lecture, sir, when it goes to the part of principle of territoriality, you said something that the test is a personal one and it is not a territorial one. So if I saw in some research and all, they brought in the principle of territoriality. So if you are saying that um, because the scholars they actually bring in the principle of territoriality under legal pluralism. So now that you told us that, hello, sir.
Well, let me first of all tell you that the reason why we said principle of territoriality is irrelevant is that the two parties to a status dispute need not be in different places. Do you understand? When you are talking about interstate conflict now, we know that territoriality comes in because the conflict only arose because two or more states are involved. But legal pluralism has nothing to do with territory. It's one of the mistakes that our scholars and our courts make. It has nothing to do with territoriality. You are amenable to a rule because of circumstances of your birth, not the territory where you are born. What bring about the confusion is because you can easily identify ethnic customer group by using geography. So that when you say it is the customary law that applies, you are looking at Eastern Nigeria, for example. If you say it's Yoruba customary law, you are looking at Western Nigeria, something like that. But that is not an element of legal pluralism. It's not an element of legal pluralism. You are not amenable to ethnic customary law because you were born in Eastern Nigeria. If you have Yoruba parents, like in Olowu now, he was from Ijesha, or he was born into Ijesha parents, or he was born to Ijesha parents. Even if he was born in Benin, he will still talk about Ijesha customary law applying to him. So the only reason why the question of possibility of it being amenable to Benin customary law arose was the way he lived his life. So territory has nothing to do with it. Why would Islamic law apply to you? Islamic law will apply to you if you are an adherent of Islam. And you can be an adherent of Islam by being born into it or by adopting it in later life. Do you know that we have Igbo Muslims?
Mm-hmm.
I have been a party to solemnizing a marriage between two Igbo Muslims. Are you going to say that because they are Igbo, Islamic law should not govern their marriage? Are you going to rightly say that because they are Igbos, if tomorrow either the wife or the husband dies, he should not distribute his or her estate according to Islamic law? What illogic would that be? So that's why we say territory has nothing to do. It has nothing to do with the question of personal system of law. Okay? The community
Yes, sir.
you were born into may be a key to understanding the ethnic customary law you'll be amenable to. But it doesn't become the determining factor of whether, for example, Islamic law should apply to you or not. It doesn't solely determine whether it's a customary law on the basis of the tribe into which you are born, or Benin customary law on the basis of the community with which you settle should be the one applying to you. That's why we said, forget about territorial tests. It's irrelevant. You catch my drift in this area if you read at least one of my articles on this subject area. Now you cannot mix the personal test together with territorial tests. In a case like Aminatu Alayo and Tuwashi, the disease had died a Muslim. She was shown to have married her husband according to Islamic law. And it was shown that the type of life she lived would qualify to be the life of a Muslim. Unfortunately, she died without leaving a child. Under Ijebu customary law, husbands do not inherit wives. So when she died without leaving a child, our own blood relations from our parents' side will be the one by the book customary law to inherit her. But under Islamic law, insofar as she did not divorce the husband, the husband will be entitled to a share of her estate. I think 1/4 if she didn't leave children. The remaining 3/4 can then go to her siblings and what have you from her blood relations. So the question was, are you going to apply Islamic law to have a share? And after all the facts have been presented to the judge said, yes, if customary law applies, Islamic law could very well be the applicable rule. But for him, the Ijebu area is not a Mohammedan area. And just for that reason, Islamic law cannot apply. Customary law doesn't apply. Okay? So if you are talking about territory, are you really drawing a line, a geographical line, to say that from this place to this place is where Islamic law applies? From this place to this place, even if you are Muslim, even if you are a sheikh, even if you are anything, Islamic law cannot apply. But is it not we ourselves that said customary law itself can be broken into two? I'm sure you have read that in legal system textbook written by Southerners. They will say customary law can be broken into two: native customary law or Islamic law. So why are we excluding Islamic law when it comes to the issue of inheritance? If we say customary law could be either customary law or Islamic law, what is our test for determining when customary law is native customary law or when it is Islamic law? It's a clear lack of understanding of the subject. So territoriality is not a test, ought not to be a test, because that would amount to double standard. Do you understand?
Perfectly, put, sir.
So any other question? Okay, let's
Put,
see
sir.
next week. Yes.
I think mine is just of a comment, sir. I haven't listened to your comments and your lecture on legal pluralism. I think the group that presented this paper, they will need to go back and do more research based on the things you have said. Because this area, the way I'm looking at it, at first it was quite abstract to me, but in the long run, when you were giving some examples, it became more clearer. Likewise, I know that there are some other persons too that have the same view of mine. So, in other words, the group that presented this paper, they need to do more research in breaking down the topic for us, sir.
Well, it is left for them. It's left for them. In academic environment, you don't condemn people's effort because they made effort. But if they want to guide their colleagues, give them a material that once they have read, they can write the exam. Definitely, they would have to, on their own, not suit their paper and do something. It may not be more than they may write a 10 pages paper that would educate in this subject area. Okay? But
Sir.
we may not have time to go back to them to present whatever they have written. What I would then do is to give you people materials to look at so that you can understand what we are trying to say. Is that all right?
Very
Yes,
well,
sir.
Prof.
So I see you next week.
Thank you, sir.
Thank you,
You're
Prof.
welcome. You're welcome.
Thank you, sir.
Thank you, Prof.
You're welcome.
Thank you, sir.
Thank you, sir.
Mm.
Thank you, Prof.
Thank you.
Prof.
Thanks, Prof.
Thank you, sir.
Thank you very much, Prof. God bless you, sir. Good night, everybody.